Good morning, everyone. This is John Graff, broker owner of Graff Real Estate in Los Angeles, California. And this is our residential purchase agreements overview. And just a reminder for those of you who are joining us, this is a very low-level, granular discussion of the residential purchase agreement. It is meant for people who are completely new to the business and those of you who are re-entering the business and haven't been doing it for a while, and things are so different that you really need to get a very nitty-gritty understanding of all the documents in the residential purchase agreement. I also want to mention that when you join the California Association of Realtors, you automatically gain access to all of these forms known as the CAR forms, and you gain that through their ZipLogix system. However, if you don't have membership with the California Association of Realtors, and we highly encourage you to do that, you may still purchase CAR's standard real estate forms from your local Association of Realtors. You can also buy them online at store.car.org. Or you can place a phone call to the REBS customer service at 213-739-8227, and they should be able to get you connected with the latest forms. It is Graff Real Estate policy that you use the latest legal CAR forms in all of your real estate transactions. So it is very important that you either become a member of the California Association of Realtors or obtain the latest forms as previously mentioned. Hey, you also have the option to use our transaction coordinator, which completely takes documents and getting stuff filled out for the most part out of your hands, and they can assist you with getting you paperwork. All you need to do is email info@graffre.com or contact the broker through your broker dashboard. All documents that are needed are included with the transaction coordinator, and the fee for that is $375 for the buyer side, $425 for the seller side. And like I said, it takes care of everything that you would otherwise need to worry about yourself. And it also ensures that you get paid through Escrow right at the close. So all in all, it's a fairly good deal. But let's go back to now the residential purchase agreement. And the very first form is actually called the disclosure regarding real estate agency relationship. And this is where you are disclosing the role of the agents in the transaction. So on this form, it doesn't matter who the seller's agent is, but it's for because in this situation you're representing the buyer, but it details what the seller's agent's duties and responsibilities are to the seller. This part pertains to you and to your buyer, what the buyer's agent does. And California does allow dual transactions, dual agency transactions, where you represent both sides, the seller and the buyer. It can be a little tricky, so whenever you do that, you do need to make sure that you are letting the broker know immediately. But that's what this clause would signify. So let us move on now, and we are going to enter the buyer. Make sure you select buyer, and you type in the buyer's name, and then you select the date. And if you have a second buyer, you would select there and fill in the second buyer's name. But for this instance, we are going to work with one buyer, Bob Buyer. Now, this is an area that I want to point out because it is an area of frequent confusion. It is the agent. It says agent, but it's really asking for the real estate broker, aka the firm. So whenever it is asking you for the name of the agent, you're actually not going to put your name, even though you are the agent, you're going to put the real estate broker firm, which is Graff Real Estate. And our license number is 019-38560. Now, where it says by, in parentheses, salesperson or broker associates, is actually where you would write in your name, Alice, agent, and that's where you would sign, fill in your Bureau of Real Estate license, and fill out the date. So again, I really want to emphasize, because a lot of agents are tempted to put their name here. That would be incorrect. You do not want to do that. It should be the name of the broker. That will be something that would come back to you in your file if that was there. That would need to be rectified. So just always make sure that that is the case. The second page here is simply the explanation of the law as to why we need to do the disclosure. So that takes care of the first document. The second document is what we call the PRBS, the possible representation of more than one buyer or seller. It's a disclosure and consent document, and basically it explains what I mentioned earlier, that in California it is possible to represent the buyer and the seller in a transaction. And this explains how that process works. It's called dual agency. Like I mentioned before, it's a little tricky. So, and there's always a possibility that it could occur without us knowing from the beginning. So we do get this signed regardless of whether or not that dual agency is actually occurring. Aha. Now we got to the actual meat and potatoes, the fun part, the residential purchase agreement and joint escrow instructions. Now the escrow instructions are for escrow. We are going to be concerned about the RPA, or the residential purchase agreement. And so we're going to go through it line by line. So the first line, number 1, is the offer, and this is kind of the very simple, most basic part of it. This is an offer from Bob Buyer. The real property address. This is when you enter the address, 123 Main Street. ZipLogix has a fun little kind of fills it in for you, so let's just go ahead and select that. 123 North Main Street, Los Angeles, California. In Los Angeles, the county is Los Angeles, and the zip code, we'll say there. The next part is the assessor's parcel number, and this is you will find on the listing in the MLS or on public records. We'll just go ahead and say that that's the assessor's parcel number. Next, you're going to fill in the purchase price. We'll go ahead and say it's $500,000. Auto-populates in the textual version of it as opposed to the numerical version. Now we'll go to Section 1, Subsection D, close of escrow. In cases where you need escrow to close on a specific date, that usually only occurs when there is a tax implication at play. That's when I would recommend filling in, checking this box and choosing the date. Otherwise, it makes most sense to check the box where you get to select the number of days. And you should select the number of days that really makes sense for the situation and what's going on in your county and local real estate market at the time. Sometimes lenders are taking longer than usual, and so it may make sense to put 35 days. Sometimes you're working with an all-cash buyer and there's no loan that could hold up the transaction, and so you could close in 14 days. So, depending on the circumstance, this is what you would adjust and choose as appropriate. Here we're going to go with 30 days because we are going to assume that this is a conventional funded loan that is supporting this purchase agreement. Agency. We already selected the disclosure regarding agency relationship. This is where you would confirm the agency relationships. So Graff Real Estate is the selling agent. Whoever the listing agent is, you would fill in here. And in this instance, they represent the seller exclusively, and we are representing the buyer exclusively. Now, your initial deposits, this is what you'll put in. This is what is also referred to as earnest money. This is, or your good faith deposits. This is what's showing the seller that you are serious. You're not just, waving around a paper offer without any actual backing behind it. So in Los Angeles County, it is typical to do 3% of the purchase price in earnest money, although it's not required. Typically, sellers will take your offer more seriously the more earnest money you are putting up front. However, you should be aware that any earnest money you put up is potentially at jeopardy as part of liquidated damages. So, 3% of $500,000 is $15,000, so we would put that there. And, in my opinion, they should remove, this part talks about how the buyer is going to deposit their funds to escrow. And in my opinion, they should really remove cashier's check, personal check, because that requires you and the broker to take hold of funds and maintain a trust account, and that complicates things too much so, and it opens up a lot of liability. And so there's really no excuse nowadays for simply depositing funds via electronic transfer. And so that's what we really advise all of our buyers to do. And if for some reason they are not able or willing to do that, you should contact the broker immediately to discuss what other options are available, including them delivering a check directly to escrow themselves. So the next part, increased deposits, that could be if your buyer is going to add more money later on. That's not necessarily something you would see often. This is the box you would check if it's an all cash offer, and notice these loan boxes remove themselves. You can't fill them in if you check all cash. That's kind of a nice thing because obviously you're not going to have a loan if you are paying an all cash. However, again, for the purposes of this demonstration this morning, we are having a loan. So the first loan, let's just say, is going to be in the amount of $400,000, which means out of the purchase price, the buyers are coming up with $100,000. They've already put in the $15,000, and so that's where this $85,000 is auto-populating, because that is the balance of down payment. That's what they'll have to put in before the close of escrow. So first loan in the amount of $400,000. This loan will be conventional financing, or in this case it's conventional financing, but this is where you would select whether it's FHA or VA or whatever the case may be. You also want to notice this says the loan shall be at a fixed rate not to exceed or adjustable. You would select that if that's the case, but under fixed rate, and it's tempting to leave this blank, but I always encourage agents to fill it out as accurately as possible, because if it's blank and for some reason interest rates shoot up to 10%, whereas they're now hovering around 4%, your buyer could still be on the hook to get that loan, even though the cost of the loan would be dramatically more expensive than a loan at 4%. So if you were to leave that blank, or you were to put something ridiculous like 25% interest or something, your buyer could be on the hook if interest rates changed or the situation changed. So to protect the buyer as much as possible, which is your duty, you should put something that's kind of a little more reasonable, like 4.5. At least today, and in today's markets. Here's where you would fill out any secondary loan information and the details of that. In this case, we're not dealing with that. And again, this auto-populates with what the balance of the down payment that the buyer needs to come up with, and again, the total purchase price. At the bottom of the document is where you see the requirements for buyer initials, both there and there if there are two buyers. That is where they will initial. It's generally on the bottom and in that location on all of these pages. However, there's also a couple other areas where initials are required, and we'll get to those in a minute. At the top, there's always the date, and a quick note on the date. This is the date of the offer, or at least the date that was plugged in here. The date of the offer. I don't know why it says 2012 either. I must have been looking back. Anyway, it's not 2012. Let's get that straight. So the date, this is just the date that the document was prepared. It's not necessarily the date of the contract agreement. Anyway, moving on to Section 8, H, verification of down payment and closing costs. This is where you want to show proof that you have that $100,000 for your down payment that you said you were going to come up with, plus whatever the closing costs may be, which for buyers in Los Angeles County are about 1.25% to 1.5% at the moment. And so you're required to submit this within 3 days unless you change that. You can change that, case may be, or you can select verification attached and include the verification with your offer, which is always what we recommend. It makes your offer cleaner, more solid, and substantiated from the get-go. Appraisal, contingency, and removal. Since this has a loan, it is contingent on an appraisal from the lender, and so the standard time frame is 17. You can try to tighten that up depending on the market conditions, or even lengthen it, but that choice is yours. Section J concerns more terms of the loans. This says that within 3 days is a standard. You will provide the letter from the lender showing that you have started your review of your pre-approval or pre-qualification. In most markets, the very best agents will already have that attached. That should really be the case, but otherwise you would get that over to them as soon as possible. The next part is the loan contingency removal. This is the longest contingency, the pre-listed contingency of 21 days, because it is typically the portion that takes the longest getting the loan approval. You can tighten that or lengthen it depending on your needs and the situation, but never remove that contingency until you actually get verification from the lender that it is okay to do so. You would check this box if there's no loan contingency. Would strongly advise against doing that if you are doing a mortgage. You should always have the loan contingency because nothing is a sure bet. So to protect your buyers and to protect yourself, quite honestly, you should always keep the loan contingency active. Section 4 is where you would check subsection B if the buyers needed to sell their own existing property in order to afford the property that they want to buy. In this case, that is not what we're doing, but if you did that, you would check this box and it would automatically add Form COP, which is contingency on the sale of buyer's property. Section 5 lists all the addenda and advisories that can or are attached with this offer. In this instance, the buyer's inspection advisory, car form BIA, is attached, and so that is selected. And you know what, let's go ahead and also select the SBSA, Statewide Buyer and Seller Advisory, because that is also thrown in there as part of what I teach agents to include as part of their standard package. Now let's go to the allocation of costs. Subsection A for inspections, reports, and certificates. The very first one, actually, let me step back. This is where the buyers and sellers basically are going to allocate the costs for all of the required inspections and reports. And, you will need to counsel your buyer clients not only on how things work in your local market, in terms of who traditionally pays for which costs, but also based on the level of competition, which costs it makes sense for maybe the buyer to absorb in an effort to make their offer more competitive. So for the sake of filling this out today, I'm going to fill it out based off of how deals are usually done in Los Angeles. And so in Los Angeles, the seller is generally responsible for paying the natural hazard disclosure, and we will typically allow it to be the seller's choice since they're paying for it. If we wanted to mandate a company or indicate that the buyer would pay for it, we would just simply indicate as such and note which company is going to be performing, or rather preparing, the natural hazard disclosure. Any other forms you would fill out here, indicate which side is paying for them. Out of the forms and reports, we get to government requirements for retrofits. The seller would pay for smoke alarm and carbon monoxide. Any other compliance with minimum mandatory government inspections would be the seller's requirement, as well as any government retrofit. Again, at least for the sake of this contract, you do need to consider, your specific buyer's individual needs when completing the contract. In Los Angeles, California, it is typical for the buyer and seller to split escrow costs 50-50, and also allow the seller to choose who the escrow holder is. In other areas of the state of California, things are traditionally done differently. So look into how things are done traditionally in your local area and, do that. Otherwise, people will think, there's something weird, you don't know what you're doing, or that it's not unfair, or that it's unfair, because a lot of times buyers pay for fees when they buy the property, and only sellers pay for fees when they sell the property. So when it comes time for the seller to sell their place, and if the buyer comes along and say, well, you need to pay this fee that you paid as buyers, and they're going to look at you and maybe be a little irritated, and you might not get your offer accepted. So it's definitely something to be aware of. The seller is going to pay for the title insurance policy, again, issued by seller's choice. Other costs. Again, I'm going to fill these out based off of our states, but you shouldn't just breeze through them. You should know how costs are split in your area. There is no HOA since we're working under the presumption that this is a single family home, but if it was a condo or otherwise in a homeowners association, doesn't have to be a condo, but if it's in a homeowners association, you would figure out how those costs need to be allocated as well. Same thing with number 5. And number 7 could also come up when there's a HOA, or even when there's not an HOA. Any other costs that need to be divided or paid for specifically by buyer and seller, you want to identify them here. Subsection B deals with the home warranty, and you would just select who the provider is, whether there's any optional add-ons like air conditioning or pool, and who's paying for it. Typically costs around $475 for a upgraded plan, so I would plug that in there. That would be safe with you. And just a note for agents with your errors and omissions insurance that comes with Graff Real Estate, that's on the per transaction fee of $135. You have the ability to add even more protection and reduce your potential deductible in the event of a legal action if you include a home warranty. So not only is it better for your buyer who takes over the home with a nice, safe, and sound warranty, but it also kind of gives you the comfort of knowing that your legal protection plan is upgraded when you include a home warranty. With not just any home warranty, I want to know, with has to be with select partners, and more information about that can be found on the broker dashboard as well. So back to this, you would, if you're not getting the home warranty, you would just simply put buyer waives the home warranty, but we're not going to. Section 8 deals with items included and excluded from sale. So we're not talking about the house. We're talking about things that may or may not be attached to the house. If your buyer wants the stove, the refrigerator, washer and dryer, you want to make sure that you are checking those boxes off. If your buyer walks through the house and says, oh, there's a washer dryer here, it has to stay, they make a big deal about it, you have to make sure you check off that washer and dryer box, because if you do not, and the sellers then decide to take the washer dryer with them, then you are going to be on the hook for getting your buyers a nice washer and dryer that fits right in that location. So you're not going to be happy about that. So make sure that if your clients point out items, make sure that they're in the contract. That's the only way to ensure that they are legally required to be there. Otherwise, there's no protection. Items excluded from sales. This notates some items that are normally excluded from sales, like furniture, of course. However, sometimes you see a sofa and it looks really good, and you you decide to ask the sellers if they would keep it because your clients really, or excuse me, if they would include it in the sale because your clients really like it. And so you can include in the contract that these other items need to be included, the following items: sofa in living room included. This is where items are excluded from sale, and sometimes on the MLS you'll notice that there are comments from the listing agent that says the vintage chandelier in the kitchen is not included, even though it's a fixture and normally would be included. Because they've put it in the MLS, you can assume that they will counter any offers that is excluded. So might as well make yourself look like a good agent and include the fact that the kitchen light fixture is excluded from the sale. Next to page 4. Top of page 4, section 9 is about closing and possession. We presume that the buyer intends to occupy the property as buyer's primary residence. If they do not intend to do that and intend to lease it out, then you should check that box that they do not intend. But in this scenario, this house is for Bob Buyer. Seller occupied or vacant property. In the case of the property being seller occupied, you want to make sure that it's clear when the sellers have to vacate. Sometimes the sellers may ask for a week-long extension to stay in the home after the close of escrow. If that is the case, you need to indicate as such in these sections, sections B and C, because under that instance, you are basically now a landlord and the sellers are now your tenants. And so you'll need to agree upon rents and security deposits and all of those lovely things, and even give them the required forms that you would give any other tenant. But again, buyer's going to take over this property right at the close of escrow, so we're not going to worry about that. Section D, tenant occupied. If the property is tenant occupied, you'll either want the property to be vacant, and you'll choose the number of days prior to the close of escrow that it needs to be vacant, or the tenant may remain in possession. If that's the case, you'll need to use CAR form TIP, tenant in possession. But we're not today. Section 10 includes statutory and other disclosures, which includes the lead-based paint hazard disclosures and cancellation rights. This includes some of the buyer's cancellation rights regarding seller disclosures that are mandatory, such as the lead-based paint disclosure, the real estate transfer disclosure, TDS, the natural hazard disclosure statement, NHD. The buyer has the right to cancel their deal within the specified time period, and as long as that contingency hasn't been lifted due to any of these reasons, and then that gives notice to the buyer of such. B is the same thing, simply regarding natural hazards disclosures. Megan's Law database, it does advise your buyers to check out meganslaw.ca.gov to find out the status of various offender's criminal history that may or may not reside at the address that they're interested in, because buyers do reserve the right to cancel the transaction for that reason as well. Let's see here. If this was a condominium or some other planned development, then Section F would be of interest, because this notes how long the seller has to provide you and the buyer with documentation concerning the condominium, such as HOA docs. 7 days is the standard, and generally I wouldn't touch that. Section 11 deals with the condition of the property, and that the property is sold in an as-is condition. This doesn't, remove your right to inspect the home and to request repairs and to request credits. It just lets you know that the home is being sold in the condition that you see it, unless otherwise agreed. Section 12 deals with the buyer's investigation of the property and all the things that you should investigate it for and why it's so important. And you should definitely read it, and you should definitely have your buyer read it, but we're not going to read it today. Section 13 deals with title investing, things that your buyer should talk to a lawyer or title officer or tax attorney about, or tax advisor, but you should not advise them on title investing. This is about how they are legally going to hold their interest in the property, either as a single buyer, through a trust, as a couple, a married couple, as joint tenants. There's all sorts of ways, and they have all sorts of legal and tax implications that are far outside the realm of real estate. And so, to avoid the practice of law or giving bad information, we always advise our clients to discuss any questions about title investing with the title officer, a tax advisor, or an attorney. Here's where we get to the time period, Section 14, for the removal of contingencies. And this is where you can do a lot to impact your buyer's chances of getting their offer accepted or not. Depending on whether or not it is a buyer's or seller's market, you'll want to tighten or loosen some of these contingencies. One note I want to make about contingencies. And let's go to B1 as an example. Buyer has 17 days as standard. You can always tighten it to 10 or to 5, whatever you want and whatever needs to happen in your market. But let's just stick with the 17. Buyer has 17 days after acceptance to complete all of their buyer investigations. That includes disclosures, reports, documents, including the inspection of the property. And so I want the thing that I want to point out is that just because 17 days has passed, or whatever the time frame has passed, doesn't mean that your contingency automatically expires. The buyer and the buyer's agent must actively remove any and all contingencies. Otherwise, they are still in effect. So again, contingencies do not simply expire. The time may expire, the time may come up, but the contingency is still in effect up until the point that the buyer physically removes it in writing, and that is the only way to remove contingencies. A lot of sellers' agents may try to push you and bully you around and tell you otherwise, that the minute, the hour, or the day has passed and now your contingency is expired and there's nothing you can do. That is not the case. And if you ever have any questions about that, please contact the broker. But contingencies must be actively removed in California. You do have the, or rather the buyer has the option of removing contingencies with their offer. That would be only in certain circumstances like an all cash or if they've already completed an inspection of the property. This comes with a lot of implications, so just make sure you know what you're doing before you are doing that. Section D deals with seller's right to cancel, which are farly less in number and in nature than the buyer's right to cancel. There's no doubt that the buyers, that this residential purchase agreement protects buyers first and foremost and gives them the most outs out of the contract. Section E here deals with notices to perform to either the buyer or the seller. If after your contingency period has expired in the situation that we were just discussing, while your contingency would still be in place, now that the contingency date has passed, the seller can send you a notice to perform. And that would basically just be giving you constructive notice that we do need you to act. Typically before you receive a notice to perform, there would be some dialogue, friendly, professional, courteous dialogue between the buyers and sellers agents. Excuse me, I was having some water. Section H here, the effect of cancellation on deposits, details quite minimally what basically the ramifications are of cancellation of escrow and whether or not it's in accordance with the agreements and what would happen to the funds. Traditionally, if you are canceling escrow and it's well within your rights, then it's done amicably and there's no problem. Final verification of condition. The buyer has the right to verify that the condition of the property is in the condition which you originally made the offer on it prior to the close of escrow. The standard is 5 days. You can tighten that up if you want to, if you do so desire, or lengthen it. Just make sure you do that in according with what is best for your buyer. Oh, just some stuff you should read, but again, nothing we need to address until we get to page 8, which section 21 details the remedies for breach of contract. And you know it's important because it is in bold. Deals with liquidated damages. This is something that you definitely want to review with your buyers. It basically details that any disagreements liquidated damages, if there are any damages, it would come out of the earnest money and should be no more than 3%. And that is something that the buyers and sellers need to agree to. Section 22 is about dispute resolution, which I was kind of thinking ahead about on the last one. It deals with alternative ways of dealing with disputes other than going to court, including mediation, saying that you will mediate, and also arbitration of disputes. That section, that is one of those sections that you need to initial that is above the normal places where you initial. So just note on page 8, there's an unusual 2 extra initial parts. There's the one there that you're used to seeing on the bottom, but there's also the one in the middle just above, and there's the other one towards the top. And a note on mediation and arbitration, those are really good ways to avoid not only the cost of court, but also the time and stress. Mediation and arbitration are great ways to get disputes resolved in a way that generally makes both parties feel like they got something out of it. The rest of the document is, again, stuff you should read and stuff your buyers' clients should read, but nothing we need to fill out until the very bottom of page 9, where we talk about the expiration of the offer. The standard is that the offer expires on the 3rd day after the offer is signed by the buyer. You may decide to, based on the situation, tighten or lengthen that time. Generally, what I do, I don't like my offers being fished around. Basically, the listing agent has my offer in hand, and so now can go to other people and say, well, we have an offer for 500,000. Can you do 505? I try to not give them very much time in which to do that, just enough time to present the offer and get us a response. So let's say tomorrow we want that by. And then this is where the Mr. Bob buyer would sign it, and any additional buyers if there were any. And note that on the bottom of page 9, you don't have to have your buyer's initial because they are signing. So an initial would be superfluous. Now on to page 10. Excuse me, bouncing around a little. This is page 10. This has to do with the acceptance of the offer. And so this is some stuff that the seller would fill out, and hopefully you do your happy dance if you get that back. But it may also say if there's a counter offer, and we will deal with that in a different webinar. But hopefully you get there. You also just want to fill out this last little block on the bottom of page 10. It kind of starts in the middle and goes towards the bottom. You want to make sure that the broker is filled out. Again, that would be John Graff, Graff Real Estate with the Cal BRE license 0193856. Buy is where you put in your agent name, Alice Agent, your license number, the date, and then you would sign where it says buy. The portion below is for the listing firm. They basically do the same thing. And then once we do get a back and forth consummated deal between the buyers and sellers and we open up escrow, this lower portion is for escrow to acknowledge it. Also at the bottom, important to note that there's a kind of hidden kind of tricks you. But page 10 is part of this agreement. They're like, hey, reminder. I mean, look at that. That's hard to find. So don't forget, page 10 needs to be initialed by the buyers. Don't worry if you forget, we will catch it. Or if you have our transaction coordinator service, they will catch it for you. So that's the RPA. The last document that's attached to it is the BIA, Buyer's Inspection Advisory. That's an addendum document, and that includes all the amazing and fun things that buyers need to be aware of. It's a one-page document. Make sure your buyers read it and sign it. Finally, because we did mention it earlier, this is the statewide buyer and seller advisory. This form doesn't need to be included right away. I encourage agents to do it just because it makes you look like you have your all your ducks in a row. It is another long list of disclosures and things that buyers and sellers should know. Make sure that they read it. Make sure you read it so that you are familiar with all of the aspects of it. But there's nothing you need to complete in this document. You just need to make sure that that you sign it, and it's completed, and that your buyers sign it, and certainly that the sellers and their agents sign it as well. So that is the residential purchase agreement class. Hopefully you got some understanding of how to fill out the different parts of the form. It is boilerplate, so you can usually just read the section in question and fill it out as appropriate for your client's needs. If you ever have any specific questions, you can always contact the broker through the broker dashboard by email at info@graffre.com or by phone 310-856-9153. And I don't see any questions right now in the chat box, but if anyone has any questions, I'll stick on for just a couple more seconds to see if there's any questions. So please go ahead and type that in the chat box. But as I was mentioning, hopefully that gives you, a basic understanding of how to complete the residential purchase agreement, and also some understanding of the basic importance of some of the sections, but also some of the finer details, like the difference between the broker and the agent, and the date prepared versus the acceptance date. So I do not see any questions in the chat box. So again, if you ever have any questions about the RPA or any other issues, do not hesitate to reach out to me or any of the other brokers on staff. This is John Graff from Graff Real Estate. You can contact me anytime at john@graffre.com. Thanks so much for joining us. And just a reminder that this webinar will be posted online in the next couple of hours. I think we're going to have it up. You know what? Let's take ourselves off the hook. We'll maybe in the next 2 days. Let's give us 2 days to get that up there. So thanks again, and good luck out there.